And welcome. It's 1 o'clock or 1:01. Okay, we've had a little technical difficulty this morning, or this afternoon, but we got it all set. Got some special guests here. I got Eric Graham, one of the other deal doctors with Five
Hello,
Star,
hello.
and Pat Drueke, our most favorite attorney that works with us. We work with Pat a lot. We throw him a lot of questions, and today we're going to talk a little bit about force majeure. And this kind of came up as a result of Hurricane Ian and the amount of damage that occurred down there. We suddenly started hearing again this phrase force majeure, which is a French phrase for major force, or in the legal sense, an overwhelming force or superior force. And I'm going to turn it over to Pat and let him see if we can enlighten us on what that all means.
Well, thanks, Don, and thanks, Eric. And first of all, leave it to lawyers to further confuse people by using various different languages to describe something that is just, as you say, superior force. And yeah, what you've identified is the most recent example of what superior force invoking a force majeure clause can be, and that's Hurricane Ian. Another recent example is the war going on currently in Ukraine. So we often see in a drafted force majeure clause certain things like acts of God, war, and generally speaking, people think of an act of God as a natural disaster, such as a hurricane. But I will start off with the concept that we're talking about. Force majeure is a creature of contract. It is not in and of itself something that if the three of us entered into a contract and didn't put a clause in there dealing with these unforeseen events, there is no force majeure. So it is something that has to be in a contract and has to be drafted. And courts in Michigan, just like any contract in Michigan, they narrowly construe or they narrowly interpret whether it applies and to what event it applies. So we can start off with, this isn't just something that automatically happens. You have to have it in a contract, and then you have to look to see what it applies to. So with that said, we can maybe have a little discussion of what the two of you think, and then perhaps we can maybe end on, if you don't have it, well, what do you do then? Are you just out of luck, or can you look at some other things? And the short answer is you can. So I'll start off with that, and if you have some other questions.
Yeah, let's start with Hurricane Ian, and then we're gonna go into some other topics. But what you just said is really important, I think, and I'd like to reiterate it, or at least throw some sort of illustration out there for our folks who are watching. So if a force majeure clause is not in a contract, it means that the force majeure itself cannot be invoked. In other words, if it's not in your mortgage, then you need to keep making your mortgage payments. Am I correct?
That's correct.
Okay. And if it's not in a purchase agreement, then there's no out as a result of that. Is that correct?
It's correct with the concept we're talking about. Absolutely.
Okay.
And if you don't, so go ahead. Yep.
Yeah. So if we're in the midst of a purchase agreement and it's going through the process, and a hurricane hits in Florida, then what happens? Because obviously that seller, let's say it's a seller that's involved in a house in Fort Myers or Naples or whatever, and that seller can no longer deliver the product that they sold to that buyer, or the buyer can no longer perform because of some event that took place as a result of that hurricane. What happens in those situations?
Well, I think you can look at it, if you don't have a force majeure clause, you can look at it from a couple of number of different possibilities. And these are legal doctrines that aren't contract dependent. You don't have to have this in your contract, but there are concepts such as impossibility, frustration of purpose, impracticability, easier for me to say than you, and perhaps you have something in your contract that might also help you. You might have a risk of loss provision in your contract. So, an example of how in one more backup, the concept of force majeure can give you two things. It can either allow you to delay performance or cancel the performance altogether. And so in terms of your example with Hurricane Ian, there are many insurers in parts of Florida that, given the hurricane, stopped writing policies or stopped issuing homeowners insurance policies. And so I think either under one of the legal doctrines I just mentioned, like impossibility or frustration of purpose, that can serve a homeowner or insurance company not writing policies or delaying writing policies or issuing them, given the hurricane, that could delay your closing. And that could, under a force majeure clause, you could use that as a delay, because without homeowners insurance, your lender is probably not going to issue a mortgage policy, and you can't go to close if you're not going to get your funds from your lender. So that's an example of how it does work. Now, that would delay the closing. If there is something that someone cannot, if your agreement requires, obviously the conveyance of the property, including all improvements thereon, in the same condition that they were when you signed the purchase agreement, and lo and behold, because of a hurricane or other natural disaster, the improvements, the house is no longer there. There's, under the force majeure clause, you may invoke it and say, I'm not going to close because it's impossible for you to deliver me the structure the same as it was when we signed the purchase agreement. If there is none, you could look at a risk of loss provision in your purchase agreement. Sometimes risk of loss provisions are drafted with a certain monetary damage provision in there to say, if the damages exceed X amount, then the buyer has this option. And if it doesn't exceed that amount, then, and the option might be to terminate. And if it doesn't exceed that threshold, maybe the purchase price is reduced and the parties proceed to closing. So it still depends on the contractual provisions and then what the particular issue is.
So if there is no, I'm trying to think of this in terms of, if a tree falls on a house 3 days before the closing, for an example, as opposed to a $1,000 water heater quits working 3 days before the closing. In my view, the hot water heater is not a force majeure issue, whereas the tree may be, but it's possible that neither of those events would cause a force majeure issue. It's more a risk of loss. Is that what I'm understanding?
Yeah, I think that you can get into those, and really into that portion of the discussion of this is really more of a risk of loss issue, because courts really, even though, I mean, it's a concept that people might view as, okay, this is my way out of an agreement, or this is my way not to perform or to delay performance. But courts, I mean, especially in Michigan, they haven't dealt with it terribly often. And when they have, you have had some issues where courts, not with respect to real estate contracts, but other contracts, have found ways to say, you know what, there is the possibility of performance. You can perform. It may make it more expensive to perform, but just because something is more expensive to perform or complete doesn't mean that it is impossible. So it really, you really have to look, when it's impossible, that's a relatively large hurdle to get over when you're looking at whether or not you have to perform, and it may well be more of a delay. So in the tree example, well, what happens if the owner of the property says, okay, I'm going to come out there tomorrow and get the tree taken off, and we'll commence repairs, and we will, agree to delay closing X amount of days, and maybe they'll do something to try to negotiate and make it more possible, although a little farther in time. How would someone deal with that? I don't know, but I think that the bottom line and most important thing for your agents and their clients to remember is look to see what your agreement provides. Try to determine whether or not there is the possibility of performing. And if there is not, whose fault was it, if any? Because you can't, the person that is at fault for something, if there is a person at fault, can never invoke a force majeure clause.
Good point. Thank you. And let's expand on that a bit, because I think that's where we get into a lot of concern here, especially with the hot water heater example. Hot water heater dies, seller says, well, not my fault, it's force majeure, or it just, act of God, whatever. It's unforeseeable and all of those things. And they attempt to invoke the force majeure clause, or concept. The problem with that is that it is repairable. As you say, it may cost them money to fix the house, to get it to the condition that it was when the offer was made. But let's talk about that from a legal standpoint. How do you enforce that?
Well, I think if I'm following your question correctly, Don, and that is, if there is an issue with the hot water heater, I mean, you certainly could look at, well, how old is this hot water heater? Okay. Did you ever have any, is it past its useful life? Is it out of warranty? Did you ever, take a look at it? And I don't think people go out there and inspect hot water heaters, but I know you can. And so in that sense, a seller of a property may not be able to invoke it. The buyer certainly is not at fault, because the buyer doesn't have any control over the hot water heater. But with respect to that, you really then have to look again at the agreement itself. And the concept of the agreement is that they're getting title to a piece of property. Certainly there are other, components that go along with the house itself. In our example, the hot water heater. But does a hot water heater leaking or breaking the day before close cause it impossible to close on the sale of this house? I don't think so. And I can't imagine that a court in Michigan is going to say, Mr. Buyer or Mrs. Buyer, you don't have to close because a $600 or $700 appliance no longer works. My belief would be that a court in Michigan would say, Mr. or Mrs. Buyer, you should go back to the seller and try to negotiate a fix, or determine whether or not the seller is obligated to repair it or replace it themselves.
Eric, what are your thoughts on this concept?
Yeah, we have some language in purchase agreements, depending on which one you're using, especially for post-possession issues, which we see a lot of, where the seller now becomes a tenant. And what happens when something breaks? And, a lot of times it will say that the seller, or in this case, it would be the buyer, the new buyer, who's now the landlord, must oversee mechanical systems. So then we got to determine, okay, define mechanical systems. Is a hot water heater part of that mechanical systems? Because, we use terms, but we never define mechanical systems. We don't define HVAC, AC, hot water heater. So we have a lot of ambiguous terms that are left up to interpretation, because they're not clearly defined. And this is what we end up seeing. And a lot of these cases go back to risk of loss, not so much a force majeure. And some purchase agreements do define that 10% threshold that, hey, if there's more than 10% damage to a home, okay, the buyer can walk away, they can terminate, or they can renegotiate on how to deal with repairs. But I don't know, my 2 cents is, Pat, how come you guys just can't make these contracts more clear?
Well, our first problem, Eric, was that we put it in French, okay? And so, you know, maybe we need to pick something else a little closer to what we're dealing with day to day. But I think what you mentioned is probably the most important thing, and that is negotiation, and maybe not necessarily negotiation, but really what negotiation stands for, and that's communication. I think, and you'll hear this from me if you ever call me, and that is if there's an issue or a potential problem, I think the first and best place to start is through a discussion with the buyer or the seller. If you're the buyer's agent, pick up the phone or however you want to meet or talk with the other agent, explain the issue, see whether there's a possibility that you can extend closing to the extent and try to keep the deal together if it's possible. If there is something that has broken or been destroyed, is it possible to get that repaired such that the parties are not in any worse position if there is a delay in closing? So I think that is really the first and best step. If that is not possible, I really believe in the case of real estate contracts, between a cancellation and a delay, you're really more on the delay side as a result of an event that might be force majeure, or in some of the other concepts that we talked about, such as impossibility or impracticability, because a lot of these deals deal with, like, think about back with the pandemic when that first started, you had issues with inspections, you had issues with closings. And so really what the net result of some of those was a delay, not an outright cancellation because of a pandemic. And given the pandemic, these clauses have received a renewed sense of attention. This concept really was established back in the 1800s, and you might have had these clauses in contracts and people just kind of skimmed over them. Now people look at them and specifically put in not just a pandemic, but a particular kind of pandemic, not just an act of God, but a hurricane or a tornado. So it really gets back to an emphasis on how are you creating your contract? Do you understand your contract? And are the agents explaining their contracts to their clients, not from a legal perspective, but just make sure you understand what you're signing here. And if there is not a provision in there for force majeure, you're not out of luck, but you just have to look at other parts of your contract or know that you've tried to work something out and you can't, and perhaps you have another legal concept to look to. But when you have a contractual provision for force majeure, if the situation's not in there, given the fact that you drafted it, would be a problem for you. Or if the event is not, or if the event is avoidable, or is predictable, or is within your control, that force majeure provision may not provide you any relief either.
And let's go back to that a bit, because as I'm looking, oops, there it went, my screen jumped. Again, the concept of these force majeure type things, and let's make it more northern and start talking about a snowstorm, shall we? It's unforeseeable. It's external to the parties involved. In other words, it's not a seller who might have looked at the hot water heater and gone, well, this thing's 30 years old, rusted out, and it could conceivably die at any moment. And it's serious enough that it renders it impossible to perform to the contract, right? So again, let's talk about the snowstorm that we're, very often have here in Michigan. The snowstorms hits, does that allow, and now the closing that was scheduled for Friday is not going to happen until Tuesday. Does that allow the buyer to get out of the deal?
I don't think it does. I mean, I think that allows a delay.
Okay.
I think that simply would, again, we're assuming that we have a provision with that in it. Okay. If we have such a provision and that's in there, I think that the result is a delay in closing. And that is the buyer or the seller, whomever couldn't make it to closing, is going to close next week or whenever.
Okay. We're winding down here. If anybody has any questions, I'm checking on our Facebook page here, but I don't see any
Yeah,
questions.
and I would say one thing, if we know that there's going to be a delay, draft an addendum so that both parties understand that there's going to be a delay, so that they're still have a meeting of the minds and they're still saying, hey, look, we're moving forward. So
Yeah.
one party can't claim a breach of contract on the other. Sometimes we do need to plan ahead with an addendum extending that closing when such delays come up.
No, absolutely, Eric. I mean, that gets back to your point earlier, and that's the best way to handle the more run-of-the-mill issue like a snowstorm, and maybe not capturing something that may or may not ever happen. But absolutely, if you run into that situation, an addendum, as you suggest, is critical.
Any other closing thoughts before we wrap this up? If you're watching, please feel free to, or watch it later, please feel free to post something, a question if you have it, and we will answer questions throughout the day and evening. And until then, merci beaucoup de nous avoir rejoint, which is thanks for joining. Have a great day.
Merci beaucoup.
Au revoir.
Au revoir.